Morning, Mr. Hartman.
Morning, Your Honor. Apologize for being late.
No problem. This is file 25-93362FH for docket call. We've got Mr. McLennan here for the people, Mr. Hartman for the defense appearing by Zoom, and Mr. Morell is present in the courtroom. And for docket call purposes, Mr. Hartman, where are we at on this case? What's our status?
Your Honor, I received the transcripts. I'm in the process of drafting a motion to quash. I would like the court to hear that. And I guess I can, the court would give me, a week to file it and then schedule a date that we could hear that. And then after that, we can decide which way the case is going to go toward resolution or trial.
Okay, my next motion day here is September 8th. If you can get that filed within the next week, then that'll give the prosecutor time to file the response. So we can continue the docket call to
Yes,
September 8th at 10:30. And you can notice up any motion
Yes,
to quash or motion that you want at that time. Anything else for purposes of today, Mr. Hartman?
No, Your Honor.
Mr. McLennan?
No, Your Honor.
Okay, Mr. Morell, we'll see you next on September 8th at 10:30 in the morning. And your attorney will likely have filed a motion for me to hear at that date and time as well.
Okay, thank you.
Okay, have a good day, Mr. Hartman. And it will be Carol Polyandro. It's file 24-93328FH. Counsel, you want to state your appearances, please?
Zachary McLennan on behalf of the people.
Your Honor, Mike Vogler representing Carol Polyandro.
All right, and Mr. Vogler, have you had a chance to review the probation violation report and recommendations with Ms. Polyandro?
Yes.
Do you have any additions or corrections to that report?
No.
The advisory guidelines range had initially been scored at 0 to 6 at the sentencing. Is there any reason to revisit that scoring?
I don't think so.
Okay, Mr. McLennan, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Mr. Vogler, go ahead with any recommendations you'd like to say on behalf of.
Judge, I think that we're coming up with 78 days credit at this time.
The report had her at 84 days. I
Oh,
think.
did it?
Yeah.
Okay. Yeah, you're right. My math is wrong. So, I know Carol I think she's got difficulties that are more personal in nature that I think if she would solve those, she'd probably go a long way to solving the problem that brought her here, this continued use of drugs. Her past, she had talent, she had good jobs, skills. Even I remember when she, I don't know if at the beginning or in the middle of the case, she had a good job at the grocery store in Onaway. Was a trusted employee. Ended up losing that employment mostly because of what she's been and gotten herself involved in. But through the course of this, I think at least she did come out of the Sunrise Center. She learned something there. She just has not yet been able to put what she learned into good practice. But I think probably she would be very wise to visit her relationships with other people and make some choices there that would probably help her in the future to avoid this kind of thing.
Thank you, Mr. Vogler. Ms. Polyandro, you don't have to make a statement today, but you're allowed to. Is there anything you want to tell me or no?
I don't think so at this time. I spoke with the parole probation officer, and I think most of what I said to her is probably what I would just say to you again. But no, not at this time.
Okay,
But thank you.
thank you. Mr. McLennan, any recommendations from the people?
Yes. Your Honor, defendant was sentenced in January and to Swift Insure and 7411 status. And things appeared to be going well until April. And since then, we've just had tremendous difficulty with numerous violations. And I can understand and appreciate a lot of what Mr. Vogler has said about defendant. But at this point, Your Honor, with the repeated violations, the people would recommend following the recommendations of the report to revoke the 7411 status and discharge on 6 probation.
Thank you. Well, Ms. Polyandro, this is, not the kind of case where I wanted you to have a felony conviction or to spend much time in jail. At the initial sentencing, the probation agent at that time, because of some of the problems you had on bond, said they did not, the Department of Corrections did not support 7411 for you. I did it anyway to try to give you a chance to avoid that felony conviction. We placed you in the Swift Insure probation program for some intensive kind of probation. We've had a lot of problems with you in that program, not just use, but also failing to report, failing to test. We tried sending you to rehab. We've given you some short sanctions, and through those, we didn't revoke your 7411. So I think there's nothing more that we could have done to try to communicate to you that if you wanted to really address these problems, we were going to partner with you to do that. But at some point, we can't make you get sober.
Right.
That's on you. We can give you tools and resources and a structure to do that. But if you are uncooperative with that, and sometimes I think that was out of fear, you didn't want to show up because you were going to jail. I mean, I understand that, but you weren't working with us as much as we were willing to work with you. And I understand what Mr. Vogler's kind of hinting at is you've got some people in your life that are not helping get you in that right direction. You have very tough choices to make about it. None of those folks are going to do a day of your time for you. They don't live your life. You live your life. So no matter what those relationships are, you got to decide what kind of life does Carol want, and go out and get that life. And if that means making some hard choices with people, that's oftentimes what it means. I think everybody hopes that you'll do that. But at this point, we have really tried to give treatment options on this, and it just has not worked, and you've not cooperated. So now we've got the only other tools in our toolbox are what's recommended today. So it certainly doesn't make me happy to do that at all, but these are totally appropriate recommendations. At this point, given your lack of compliance on probation, your multiple violations, I'm going to revoke your deferred status, and we're going to enter a judgment on the felony conviction at this time. I'm also going to revoke your probation in order that you serve 6 months in the Prescott County Jail. I will give you credit for 84 days previously served. I would approve you for any kind of trustee status or any programming that the jail would have with any credit programs they would have for that. And also any fines and costs that were assessed that they remain due and owing in the amount of any unpaid balance. Ms. Polyandro, because we are entering a judgment on the case now, you can file an application for appeal if you want. If you wanted a lawyer, I'd give you one, but you'd have to ask me within 6 months. We're going to hand you a piece of paper explaining that process and ask you to initial one copy for us. So we have a record, we gave it to you.
Okay.
And the other one is for you to fill out if you want to take it. Okay. When you're released from the jail, you're not on probation anymore. And then you got to decide what you want to do. And if you need any help, still reach out to, folks that'll try to get you into treatment before you catch a new case.
Okay.
Okay? Good luck.
I'm gonna have to print one, I'll take it.
Okay, we'll get one down to you. All right, good morning. We'll go back on the record in the 53rd Circuit Court for the County of Presqu'île. We are providing public access both in the courtroom and also online. And we have a civil case for pretrial Trudgeon v. Weckworth, file 25-3395CH. Come forward, counsel. Counsel, you want to state your appearances, beginning with plaintiff?
Yes, my name is Kathleen Kerrigan. I'm appearing for Mary Trudgeon, Denise Shook, Wayne Wetworth, and Renee Rogers.
Good morning. Victoria Padula appearing on behalf of defendant Roy Weckworth, who is present in person in the courtroom today.
Okay, and good morning, Mr. Whitworth. You can have a seat at the table if you wish. All right, so we're here. We just did a scheduling order last month. The parties told me they were moving this case along pretty quickly. Ms. Kerrigan, on behalf of plaintiff then, where are we at in terms of status of any resolution or readiness for a trial?
So they will receive our disclosures today. Then we'll send proof of service to the court. We haven't heard back from our most recent settlement offer that last I heard from the other party was just before our previous hearing. So there may still be hope of settling, but we're preparing as if we're going to be having trial.
Ms. Padula, what can you tell me about that?
Yes, Your Honor, everything Sister Counsel has expressed is accurate. We are just working with, we do anticipate, to move forward. Hopefully we're going to reach some sort of agreement here shortly. We do anticipate responding very, very soon, if not today. We're hoping that we are able to resolve this matter, but in the event that we are not, we will proceed as scheduled and don't anticipate any further adjournments or additional time at this current date.
Okay, well, let me ask you, I mean, I had the case on kind of a fast track because that's what you guys told me you preferred. So I can continue the final pretrial either to September 8th, which is only about 4 weeks out, or to October 6th, about 8 weeks out. What's your preference, Ms. Kerrigan?
September would be our preference.
September fine with you, Ms. Padula?
That's no problem, except I believe that my client is going to be out of town in the beginning of September, so I'm not sure if that will be ideal for that reason alone.
Okay, Mr. Wetworth, September 8th, is that the day you're available or no?
No,
Okay.
no, sir.
All right, well, we'll continue the pretrial to October 6th at 11 a.m. then.
Thank you.
And Zoom appearances are allowed by any parties that wish. Anybody that wants to be present in the courtroom is, of course, welcome to do that as well. So we'll set it for October 6th at 11 a.m. Anything further from plaintiff?
No, thank you, Your
Anything
Honor.
further from defense?
Nothing further, Your Honor. Thank you.
And have a great day.
I'll take it.
So back on the record, and we have next people be twos, file 89-91188. Counsel, you want to state your appearances, please?
Zachary McLennan on behalf of the people.
And good morning, Your Honor. Christopher Parks on behalf of Mr. Tews.
And I spoke with counsel at the bench. Mr. Tews has an application to set aside a 1989 conviction in this county. And he has some convictions in another county that are still being sort of sorted out some of the details. So as I understand, Mr. Parks, you'd like about 60 days to sort out what's going on over there. Is that right?
That's correct, Your Honor.
Any objection to that, Mr. McClellan?
No, Your Honor.
All right, so I'll continue this then to October 6th at 11:10 a.m. Anything further from the petitioner,
No, Your Honor. Thank you.
from the people?
No, Your Honor.
Okay, we'll see you then.
Great. Thank you, Your Honor.
Who's our doctor today?
Well, that took a turn. Judge Aaron J. Gauthier opened the morning with People v. Carol Polyandro, a probation violation hearing that ended up being more about life decisions than just legal consequences. Defense attorney Mr. Vogler didn't dispute the probation report and even acknowledged that some personal relationship choices might be fueling his client's repeated struggles. Polyandro opted not to speak, leaving the record to her attorney's remarks. Prosecutor Mr. McLennan, while acknowledging those personal factors, pointed out the reality since April. Violations had piled up and earlier leniency hadn't worked. Judge Gauthier's response was part firm accountability, part heartfelt advice. He reminded her that she'd been given an unusual chance to avoid a felony conviction through a deferred status and an intensive probation program, but repeated. Non-compliance left him no choice but to revoke that status, enter a felony judgment, and impose 6 months in the county jail with credit for 84 days served. His closing remarks were almost fatherly, emphasizing that her future rested on the choices she made and the company she kept. The tone shifted as the court moved into a civil pretrial. Trudgeon v. Weckworth, both sides represented by Ms. Kerrigan, and Ms. Padula reported that settlement talks were still alive, but no deal had been reached yet. Scheduling turned into a small logistical puzzle when the defendant said he'd be out of town for the September date, so the judge pushed the final pretrial to October 6th. It was routine, but a nice contrast in tempo after the emotionally heavy probation matter. Finally, in People v. Twos, a much simpler administrative step-in application to set aside a 1989 conviction was pushed to October 6th to allow time to sort out related convictions in another county. No objections, no tension, just a clean continuance. What tied the whole morning together was Judge Gauthier's consistency. Whether dealing with a troubled probationer, a civil scheduling conflict, or a straightforward continuance, he balanced efficiency with a personal touch. Even in the most serious moments, his manner stayed calm, his explanations clear, and his courtroom running right on track. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.